Good evening. My name is Heather Cron. I'm one of this year's Dean's Cup coordinators. Thank you so much for joining us for the final rounds. Before we get started, I just have a couple of housekeeping items. First, to minimize disruptions, would you please turn off or silence your cell phones? Once the arguments do get started, we ask that you please remain in the auditorium, again, just to minimize those disruptions. And finally, at the end of the arguments, we invite you to the third floor mezzanine to join us for a reception. We are so excited for this year's Dean's Cup. The Dean's Cup is Duke Law's premier oral advocacy competition. Deans E.R. Lottie and J.D. Johnson founded it in 1963, and the Moot Court organizes the competition annually. Students began their work on this competition during the fall preliminary rounds. They each argued 4 times before faculty and alumni judges. The 16 highest scoring competitors from those rounds moved on to the semifinals, and now we're here down to just 4 competitors. This year's finalists are Meredith L. Compton and Zachary Ezor, arguing for the petitioners, and Zachary and Ferguson and Will P. Sowers, Jr., arguing for the respondents. Their efforts today are the culmination of a vigorous competition, and they, together with the coordinators, wish to thank the incredible Duke Law community for all of their support throughout this process. We are especially grateful for the Dean for his generous support of the Moot Court Board. We also wish to thank Professor Andrew Sierra for his help organizing the competition and designing the problem. We also want to thank the many faculty and alumni judges that really helped judge the competition, that helped coach our competitors throughout this process. We also had some wonderful students competing and helping with mooting. Because of this, I think that this really just helps highlight the supportive community that we have here. We look forward to hearing our oral arguments shortly, but first, Meredith and Maria Mollis will introduce the problem and our judges.
This year's problem is based on the Seventh Circuit's decision in International Union of Operating Engineers versus Schimel. The petitioners are 2 local unions challenging a Wisconsin right-to-work statute which prohibits employers from imposing union fees on non-union members. The unions challenge the statute on 2 grounds. First, they argue that the state statute is preempted by the National Labor Relations Act. Second, they argue that the statute constitutes an unconstitutional taking in violation of the Fifth Amendment. It is my pleasure and an honor to introduce our 3 presiding judges for the evening: Judge Srinivasan, Judge Pamela Harris, and Judge Amul Thapar. Our first justice for this evening's arguments, Judge Srinivasan, was appointed to the U.S. Court of Appeals for the Sixth Circuit in May 2013. He graduated from Stanford University in 1989, as well as Stanford Law School and Stanford Graduate School of Business in 1995. He has served as a law clerk to Judge J. Harvey Wilkinson III on the Fourth Circuit Court of Appeals and to the U.S. Supreme Court Justice Sandra Day O'Connor. Following a brief period in private practice, he joined the law firm O'Melveny & Myers, where he would later return as partner of the firm's Supreme Court and appellate practice. He has argued 25 cases before the Supreme Court and has taught appellate advocacy at Harvard Law School. From 2011 until his appointment to the U.S. Court of Appeals, he served as the Principal Deputy Solicitor General of the United States. Our second justice this evening is Judge Pamela Harris. Judge Harris was appointed to the U.S. Court of Appeals in July 2013. She graduated summa cum laude from Yale College in 1985 and from Yale Law School in 1990. She served as a law clerk to Judge Harry T. Edwards of the U.S. Court of Appeals for the District of Columbia Circuit and to Justice John Paul Stevens of the U.S. Supreme Court. In 1993, she joined the U.S. Department of Justice, where she served as an attorney advisor at the Office of Legal Counsel and later as Principal Deputy Assistant Attorney General at the Office of Legal Policy. She joined O'Melveny & Myers Appellate and Supreme Court Litigation Group in 1999 and became partner in 2005. She also co-directed Harvard Law's Supreme Court and Appellate Practice Clinic and served as visiting professor at Georgetown Law, where she was named the executive director of the Supreme Court Institute in 2009. Our final justice for this evening is Judge Amul Thapar. Judge Thapar was appointed to the U.S. Court of Appeals for the Sixth Circuit in May 2017. He graduated from Boston College in 1991 and from UC Berkeley Law School in 1994. Following graduation, he served as a law clerk to Judge S. Arthur Spiegel of the U.S. District Court for the Southern District of Ohio and to Judge Nathaniel R. Jones of the U.S. Court of Appeals for the Sixth Circuit. He also served as an adjunct professor at the University of Cincinnati. He joined the law firm Williams & Connolly and served as an AUSA at the U.S. Attorney's Office in Washington, D.C. from 1999 to 2000 before returning to private practice. From 2002 to 2006, he served as he was the U.S. Attorney for the Eastern District of Kentucky before his nomination to the U.S. District Court for the Eastern District of Kentucky. So without further delay, we will now begin the 2018 Dean's Cup.
All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right. Be seated, please. We'll hear argument now in number 15-40238, International Union versus Schimel. Petitioners?
Mr. Chief Justice, and may it please the court, my name is Meredith Compton, and I, along with my co-counsel, Mr. Zack Ezor, represent the petitioners in this case, the International Union of Operating Engineers. With the court's permission, I would like to reserve 3 minutes for rebuttal.
Sure.
Your Honors, this case is about preserving the balance Congress struck between robust federal protections for unions and a discrete but narrow authority reserved to states. Wisconsin Act 1 upends this balance by eliminating the ability for unions to seek any compensation from non-members in violation of federal law and in violation of the Fifth Amendment. I will address the first issue of federal preemption, then Mr. Ezor will discuss the second issue of an unconstitutional taking. Now, Your Honors, Wisconsin Act 1 is preempted by the National Labor Relations Act because it far exceeds the limited scope of authority relegated to states under Section 14B and removes all protections against free riders allocated in Section 8A3. One of the central aims of the National Labor Relations Act was to protect continued union health. Congress recognized that unions play an important and valuable role in labor management relations, and thus created a framework that was designed to protect that role and ensure continued union viability for years to come.
In your brief, you mentioned membership having two different meanings in these provisions. Can you explain that to me? Because I'm not sure I follow why the court should give membership different meanings in these provisions.
Yes, Your Honor. Well, the same word means the same thing. It's certainly a concept this court has recognized. That concept readily yields when circumstances indicate that Congress did not intend identical meanings.
But you point to legislative history, and there's legislative history going each way. I mean, legislative history is kind of like the Bible. There's something there for everyone. And it seems to me here the legislative history points both ways. So why wouldn't we interpret it the same way in the same, act, so to speak?
Well, Your Honor, looking at just the text, not getting into the legislative history, Congress wrote the two sections differently. Section 8A3 begins with a broad prohibition against any union security agreements, then is quickly followed by two provisos that are unique to Section 8A3 that carve out large exceptions to that broad prohibition, ultimately only prohibiting the closed shop arrangements. In contrast, Section 14B is a single paragraph, recognizing a single state power, the ability for states to regulate those agreements requiring membership in the labor organization.
So under your argument, does the meaning of membership vary within 8A3 itself, as between the initial clause and between the two provisos?
No, Your Honor.
So it's constant through 8A3. It just takes a radical detour when you get to 14.
Yes, Your Honor, with respect to the scope of authority given to states under Section 14B versus the authority given to unions under Section 83.
Why couldn't they have limited that expressly in 14 rather than make us do some gymnastics to change the definition.
Well, Your Honor, I can't speak to why Congress wrote the specific language the way they do, but rather that the legislative history demonstrates that what they were really concerned with was compulsory unionism.
But Counsel, wasn't Congress aware when it enacted 14B that there were a lot of states with right-to-work laws just like this one already on the books? And is there any indication in the legislative history that Congress thought it was invalidating those laws?
Well, Your Honor, with respect to those 7 state laws in 1947 that were in existence and that Congress cited, first, just because Congress cited those state laws is not evidence that they supported or ratified those state laws.
Well, it seemed pretty clear that Congress had in mind the states are doing their own thing and they're kind of experimenting, and the point of 14B is to allow that. And is there anything to suggest that Congress thought it was actually invalidating some of those laws?
Well, Your Honor, what the legislative history demonstrates is that when members of Congress were referring to those existing state laws, they only viewed those state laws as regulating closed shop agreements that certain states had
So
decided.
Congress was just wrong. It didn't understand what the state laws actually provided for.
It's based on the legislative history. It's clear that Congress only viewed those state laws as regulating those closed shop agreements, which it then banned in Section 8A3 and gave states the authority to regulate other agreements that require membership in the union, and that the legislative history demonstrates this concern with compulsory unionism. And when Congress referenced this compulsory
Right, but it
unionism,
doesn't get to these, right, as far as what I saw, it doesn't get to these 7 state laws.
with respect to referencing compulsory unionism?
Yes.
Yes, Your Honor. I'm speaking to broadly what Congress was concerned with in Section 14.
Right, so the legislative history actually doesn't address Judge Harris's point, right?
Well, Your Honor, the members of Congress, in referring to existing state laws, did refer to the fact that states had chosen to ban closed shop agreements. And nowhere in the legislative history is there any evidence that members of Congress believed that those existing state laws allowed for states such broad regulatory authority as Wisconsin has asserted today. They only reference the existence of state laws that banned these closed shop arrangements.
But then what was the purpose of 14B? Because I thought Section 8A3 itself precluded the closed shop agreements.
Yes, Your Honor.
So then so if Congress thought that's all states had in mind, is prohibiting closed shops, why did it need 14B if it had already prohibited it? Do you know what I'm saying?
Yes, Your Honor, because it recognized that states do retain some power to regulate compulsory unionism, with closed shop agreements being that most extreme form of compulsory unionism that some states had already chosen to ban, but that states could regulate similarly compulsory unionism agreements like union shops or maintenance membership shops. But at no point did Congress, in enacting Section 14B, authorize or signify any intent to authorize such broad regulatory authority that goes beyond compulsory.
I think I still don't quite understand what work 14B does. Because as I understand the intersection between 8A and 14B, especially when we understand 8A in light of our prior decision in Beck, we already know that 8A doesn't authorize and federal law prohibits arrangements whereby a fee is exacted, something more than a representation fee is exacted.
Yes, Your Honor.
And if that's true, then under your argument, what work does 14B do? Because you would think that states would be allowed to prohibit something that's not already otherwise prohibited by 8A, but it seems to me under your argument, actually all states are allowed to prohibit is something that's already prohibited under 8A.
Well, with respect to pre-Beck assessment, 83 only banned the closed shop arrangements and allowed states to regulate other types of compulsory unionism.
So let's just talk about post-Beck. So and then we can get to whether Beck actually changed something. But post-Beck, what work does 14B do?
Arguably, Your Honor, it is rendered superfluous by this court's decision in Beck, as this court did recognize a previously unforeseen constitutional limitation on Section 8A3. But in so recognizing, that didn't change the narrow purpose and scope of Section 14B. And under normal circumstances, this court should avoid rendering any language
And you said arguably it renders it superfluous. What do you mean by it? It seems like you're leaving open a way in which it arguably does not. Is there any way in which post-Beck 14B does any work?
If this court decides to draw a line at lower than representation fees, then Beck would not render Section 14B. If this court thought that Section 14B should still do some work with respect to state regulatory authority, perhaps drawing the line at something like a pro rata arrangement in which you pay for the services provided, but anything sought more than that, the states can regulate. But what Wisconsin Act 1 has done here is to drive the charges down to zero. There are no lines that Wisconsin has drawn. It assumes complete authority over regulation of union security agreements, far beyond compulsory unionism by any reasonable definition, as Section 14B is limited to. So even if this court wanted to draw a different line, to leave something open for states to do under Section 14B, it should not draw the line at zero as Wisconsin
If
has
we don't buy your definition of membership or your changing definition of membership, do you lose?
done. No, Your Honor, because if Wisconsin Act 1 doesn't fall under preemption, it renders an unconstitutional taking under the Fifth Amendment, which Mr. Ezor will
Okay,
address in more
but
detail.
you lose on the preemption question then.
Potentially, Your Honor, if this court finds that states can drive charges down to zero, that membership constitutes just a single cent paid to the union, then it would still be an unconstitutional taking, but it wouldn't be preempted under this court's interpretation of membership.
Can I
So, go ahead.
how many states currently have laws like Wisconsin's?
I believe currently there are 28 states that have laws on the books.
And some of them are not particularly new, right? Some of them go back pretty far.
Yes, Your Honor, some have been on the books for several decades.
Right. So it's fair to describe this as a widespread and long-standing feature of state law?
Yes, Your Honor.
And you think all this time it's been invalid under the NLRA?
Yes, Your Honor.
That's what you want us to hold?
Yes, Your Honor, simply because something's been on the books, even for an extended period of time, does not, by evidence alone, indicate that it is inherently constitutional or in line with federal law. And in fact, this...
Well, it would be odd if Congress had not intended this result, that it didn't do anything in all of those intervening years, right?
Well, Your Honor, we can't infer from congressional silence either for or against those state laws. But this court expressly left open in retail clerks the question at issue today, whether states under Section 14B can regulate these less compulsory, less stringent agreements. And the language of those sections, along with their underlying purpose and this core central aim to protect union health, demonstrates that states should not be given such broad regulatory authority to eliminate the protections under Section 8A3 and undermine that core aim of protecting union health.
So part of the force of your submission about protecting union health is this idea that in the absence of a ruling in your favor, there will be a big free rider problem.
Yes,
Right.
Your Honor,
And one question I have about that is, if, as the other side says, there's such a thing as a members-only union, whereby the union actually can decide, if it doesn't want to be the exclusive bargaining representative, at least that it only wants to represent the interests of members, then is there a free rider problem? Because that seems like it handles itself, because at that point, there are no free riders if you decide, if you elect to be only a members-only union, and nothing in law compels you to be something other than a members-only union.
Well, Your Honor, my understanding is that the members-only arrangement is a Wisconsin-specific statute, that the NLRA only imagines a situation in which the union represents both members and non-members
So,
elected.
wait, I'm sorry, I didn't understand that. So it's Wisconsin only has members-only unions?
That's my understanding, Your Honor. In fact, in the dissent in Sweeney, they bring up the fact that hypothetically we could have a regime in which there are members-only unions, but that the regime we have now, the NLRA, creates a regime that the unions represent.
But then why doesn't that eliminate your free rider problem in Wisconsin? So why are we worried about this in this case?
Because the union in this case and other unions like it have been elected to represent the entire
But they
bargaining.
didn't
But they've
have.
elected to be elected.
Go ahead. No, you go.
They have elected to be the exclusive bargaining representative. They didn't have to do that, right?
Certainly, Your Honor, they didn't have to do that, but simply because they didn't have to volunteer to be elected doesn't mean that you avoid the free rider problem, because Congress imagined.
No, but they make a decision when they elect to be elected, and they know the consequences of that in Wisconsin.
Yes, Your Honor, but Congress, in creating the NLRA, wanted unions to elect to take on the representation for members and non-members elected.
Does the NLRA preempt a Wisconsin law that allows for members-only unions?
Not necessarily, Your Honor, but that's not the question we have before the court today. The court.
But it seems like it is the question raised by what you just said, which is that the NLRA does not contemplate this kind of members-only union and imposes different duties on unions.
Yes, Your Honor, if there were a situation in which the union at issue was a members-only union, that might raise other preemption concerns, as that would, Your Honor, I believe my time has expired. May I briefly respond?
Sure.
as that would undermine the central aim of the NLRA to have union health and have union representation for members and non-members alike. Thank you.
Thank you. Mr. Ezor.
Mr. Chief Justice, may it please the court. Your Honors, this court has an additional reason to declare Act 1's invalidity. If allowed to stand, Act 1 affects an unconstitutional taking in violation of the Fifth Amendment. Now, the unions have a duty under federal law to represent both members and non-members alike. And the NLRA, as my colleague Ms. Compton described, allows unions to enter into agreements with employers so that they can recoup the cost of those services they're required to provide. Act 1 completely guts this arrangement by denying the unions any and all opportunity to recover from non-members the cost of those services.
So when we require doctors to treat people that need emergency medical care, is it an unconstitutional taking?
No, Your Honor, it is not.
Why?
It's not because usually those are indigent individuals, and usually the hospitals have some
Well,
other...
where's that exception in the takings clause? I missed that in the Fifth Amendment.
Well, Your Honor, the difference here, and really the daylight between that example and the case that we have here, is that the hospital receives some additional benefit from taking on those individuals. Usually it's either they receive Medicare or Medicaid funding, or...
Well, but I mean, they could make, the union could make, or I'm sorry, Wisconsin could make that argument here, that by being the bargaining representative for everyone, you carry more weight with the company, and so on behalf of your clients, you can get them greater benefits.
Well, Your Honor, as this court said most recently in Horn v. Department of Agriculture, a condition on entering into a marketplace can still, in some instances, affect a per se taking. And this is one of those instances. And the reason is that the unions basically have this duty to provide services to anyone. Wisconsin has created a state-sanctioned right, regardless of ability to pay, for non-members to waltz into a union office, demand representation from a union attorney.
What's the property that's being taken?
Your Honor, the property can be thought of in a couple ways, but most concretely, it's the money in union treasuries that has to be expended on the non-member's behalf.
And who's taking it? Who's taking that money?
Well, it's true that the duty of fair representation operates in confluence with Wisconsin's Act 1 here, but as this court said in Howlett v. Rose, states are required to take into account pre-existing federal duties when they legislate, as though those rules had emanated from their own legislatures. And so really it's the denial of compensation that is making this an unconstitutional taking here.
But even under that rationale, is it, for you to win, it has to be the state that's taking the union's money?
Well, Your Honor, it's the state that is affecting the unconstitutional taking by denying compensation. So really the value is being absorbed by the non-members in this instance. It's a transfer of property from one private entity, which is the unions, into the pocket of another, which is the non-member, at the behest of the state of Wisconsin.
And so does it seem like a reasonable scheme in that situation if the state is the one that's, at least in some kind of metaphysical way, taking the money, that the state should be the one that pays the money back?
Well, Your Honor,
Seems something like of a mismatch here.
well, Your Honor, that's one of the reasons why we've asked for an injunction in this case, is that it is impractical to imagine a scenario where the state has to recompensate the unions for
Right.
services they provide to non-members. And so we recognize a taking here and ask that the law that's affecting that taking be enjoined for that reason. It's really a pragmatic concern.
And are there precedent under which the remedy for a taking, the go-to remedy for a taking is an injunction rather than what the takings clause itself says is the remedy, which is just compensation?
Your Honor, not that I'm aware of. However, it's not a large analogical stretch to imagine that the same result, which is envisioned by the takings clause, could be accomplished by an injunction in addition to direct compensation. Although this court has established a clear and administrable rule for what amounts to just compensation. And that is compensation that's fair market value of the property being taken at the time of the taking. Now, the Seventh Circuit wrongly held that the unions are somehow justly compensated by their positions of exclusivity. But the problem with that reasoning is that exclusivity itself, as we've discussed, is already fairly tempered by the duty of fair representation. And so there's an equilibrium here. The unions have a duty to represent members and non-members in exchange for this position of exclusivity. that they take on. And so to say that that exclusivity also compensates unions justly for these services they're required to provide to non-members is really inapt. And furthermore, exclusivity itself as a concept, to the extent that there is any value, it's nebulous. In comparison, the discrete
I'm not sure I follow. Why is it nebulous?
Well, Your Honor, the discrete services that the unions have to provide to non-members have real financial costs. We can point to the accounting to show exactly how much that lawyer was paid or exactly how many miles that business agent drove. In comparison, exclusivity is something that really only has value
Well, it gives you bargaining power value.
I'm sorry, I didn't hear you.
It gives you bargaining power value, correct?
That's correct, Your Honor. But that value cannot be thought of as the fair and perfect.
Then why not go back to the earlier question? Why not just go to a members-only union if that's what you're worried about?
Well, because, Your Honor, as my colleague was arguing, the NLRA itself envisions a role for unions to take on the mantle of exclusivity. And to the extent that we're concerned at all with congressional purpose here, we have to be hesitant to adopt any sort of argument that envisions unions exiting that role of exclusivity. And moreover, the facial takings claim that we've alleged here applies to all unions currently serving as NLRA unions. That is, those unions who have been elected as exclusive representatives and are serving in that capacity now. So to envision exit from that realm really would be contrary to the purpose of the NLRA and also would go against court precedent for arguments that they simply prove too much. If I could just point your attention to...
Can I just actually, in thinking about the role that the NLRA envisions for the unions, could a state require a union to say, put out a notice for its members, just a disclosure notice, like here are your rights under the collective bargaining agreement, we will do grievances for you, we'll arbitrate for you. Could a state require that kind of a notice, or would that be a taking? Because it would require the unions to spend the time to put together the notice and send it to their members. I'm trying to figure out what doesn't count, what kind of regulation does not count as a taking for you?
Sure. Well, Your Honors, the hallmark of any taking is a taking that goes too far. And that's the language that goes all the way back to Pennsylvania coal.
And would this go too far that the union would have to pay the cost of this notice and, say, hand it out to its members?
No, the notice provision that you described, I don't think would. However, that's not what we have here.
Well, no, I get that, but I'm trying to figure out what the limiting principle is for your argument.
Sure. It might be helpful to think of another case for a limiting principle, and that's Lucas. So Lucas dealt with a discrete parcel of land, the entire economic value of which had been destroyed. And so when you have a situation where a union has to go to bat for a non-member in a way that their expenditure is completely destroyed from the perspective of their treasury, that is, all the value has been transferred to the non-member, that feels much closer to a per se.
Doesn't that just depend on how you define the denominator? Because it's true that if you say that the expenses that I care about are the expenses that are bound up in this representation, well, it's 100% of that. But then if the expenses you care about are the expenses that it costs to notify somebody, it's 100% of that too.
Yes, Your Honor, that's correct. And we would say that the denominator here is the individualized services that are being provided to non-members. It's a recurring taking.
So would every notice to non-members count?
No, Your Honor, it would not necessarily. But these sorts of real tangible costs that the union is putting up for a non-member.
Those are real tangible costs.
That's true, but they don't go to the severity, the same severity that really pervades this court's taking.
So if you don't have any arbitration or anything, but you're just providing exclusive bargaining, which you would do for all of your members, then that's not a problem, is what you're saying. So if Wisconsin created a statute that said, if you arbitrate, you have to pay the fees of that. But if all you're getting is the bargaining, no problem, you'd be okay with that.
Your Honor, I can't say whether we would or not, but that would be perhaps some line drawing that the court could engage in, were they to decide that Act 1 were not completely preempted, but that there was still a question of a taking here. So it's really up to the court to decide whether, as my colleague spoke to, there's any wiggle room in 14B that lower courts might be able to follow. But here we have a law which prohibits the unions from recouping any and all compensation from non-members, and that is severe enough to really be classified as a per se categorical.
So if your colleague also raised the prospect that you could maybe calibrate this in some way, and what's particularly obnoxious about Wisconsin's law is that it prohibits any compensation whatsoever. So if you had a state that didn't quite go so far, and it had something short of that, would we say that that's not a taking in that state, but what Wisconsin did is a taking?
Perhaps, Your Honor, and I think this actually goes to Justice Harris's question earlier about the pre-existing state laws, and that is that perhaps these actions haven't been brought until recently because the severity experienced by the unions just was not enough to push them over the line into a litigious posture. So the fact that these laws have been on the books for some time really is not evidence that they're valid. Moreover, it's just that unions were, frankly, once incredibly strong and have since been weakening. And so we've reached sort of a tipping point where it's worthwhile to bring this sort of litigation.
Can I ask you a question? So let's just assume that I'm not completely persuaded by your takings rubric. And we've talked about some of the potential conceptual gaps between a traditional takings claim and the kind of takings claim you're presenting. And I'm not saying I'm not persuaded, but just assume that I am for purposes of this question. What's lost if instead of looking at it as a taking, you make the same arguments you do, but grounded in substantive due process like Justice Kennedy did in his opinion in Eastern Enterprises?
Well, Your Honor, I would be hesitant to rely on that opinion in Eastern Enterprises, which perhaps under the Marks rule, that was the concurrence, if I believe correctly. We can draw that would be the opinion to really focus on, although Eastern Enterprises was a plurality opinion. Frankly, I'm not sure. We've been framing this question as a takings because we believe that it really is the best way to analyze what's going on here. So that would be a question to pursue for another day.
What about your opponent's argument that your takings claim isn't ripe?
Well, Your Honor, both the district court and the Seventh Circuit agreed that what we've alleged here is a facial takings claim. And facial takings claims sort of step outside of the Williamson County rubric. They avoid the exhaustion requirements of that rubric and allow a plaintiff to bring a case directly into federal court kind of at step one.
What does that mean, a facial takings claim? Because the takings clause itself talks about just compensation.
Right. It's a little bit mushy. The facial takings claim really means that by its mere enactment, a law has affected an unconstitutional taking. And so for our union...
But it's taking without just compensation.
That's right, Your Honor.
So it seems like you have to seek just compensation. So I don't understand how you can do a facial challenge to something.
Well, really there are two ways to think about it. One is that the mere enactment of Act 1 deprived unions of the opportunity to even begin negotiating these agreements. And if you look in the record beginning on page 18, you'll see an example of the type of record that we would have hoped to negotiate with an employer. So that opportunity has been deprived. So there's a kind of a small but initial taking there. But then the second is that all similarly situated unions who are serving as exclusive representatives now have to contend with the sort of specter that this taking will occur as soon as they renegotiate their representation agreements.
Why can't they sit down and negotiate the agreement and then go to whatever it is, the Wisconsin Claims Court, and say, all right, that cost us $10,000 and we're here for our $10,000?
Well, Your Honor, as I spoke to earlier with Justice Srinivasan, it would be impractical to do that, frankly, because what we have here is a recurring taking. Each and every time a service is provided, it really wouldn't make sense for the unions to have to then go to court and ask the state for compensation.
So what if you had, what if the way that Wisconsin law worked was that you enacted Wisconsin law, which is called, is it Act 1? We're calling it Act 1.
Yes.
So then in conjunction with Act 1, it also enacts Act 2. And what Act 2 says is, if you think that you've been denied compensation, if you think this law denies you compensation that you're owed, here's the way that you try to get compensation. You bring the following kind of action in the following Wisconsin court, and it's actually in the letter of the law that was enacted, and it's called Act 2. Would you then say that just by virtue of the enactment of Act 1, that's a facial taking, and therefore I can go directly into federal court? Or would the fact that the Wisconsin law itself provides for a mechanism of just compensation cause you to think differently about it?
We would still say it's a facial takings claim, Your Honor, and the fact of the matter is Wisconsin does have an inverse condemnation procedure, which other unions have pursued in state court. And I see I'm out of time here. May I just briefly conclude?
Sure.
Your Honors, this court both should and can avoid the takings issue altogether by finding that Act 1 is preempted by the National Labor Relations Act. But if it doesn't, it should recognize that by depriving unions of any and all opportunity to recoup compensation for these services they're required to provide, an unconstitutional taking has occurred. Thank you.
Thank you. We'll hear from respondents now. Mr. Ferguson is first.
Mr. Chief Justice, and may it please the court, my name is Zack Ferguson, and I, along with my co-counsel Will Sowers, represent the state of Wisconsin. The unions asked this court to do two things no federal court of appeals has done in the history of the Taft-Hartley Act. First, they asked this court to invalidate the right to work laws of 28 states by effectively reading Section 14B out of the statute. Second, they asked this court to hold that the union's services are property and that the government commits a taking whenever it prevents unions from charging non-members for services they never asked for in the first place. The lower courts in this case correctly rejected both of these arguments, and this court should affirm. So first, Your Honor, Section 14B protects Act 1 from preemption, and this follows clearly from the text of the statute.
Counsel, let me just stop you right there. I don't understand your reading of an agreement requiring membership. Just seems so counterintuitive. Why? Who thinks of paying a fee for a service as a membership agreement? I mean, am I a member of the hotel where I stayed last night?
Your Honor, this court, in fact, in Beck, thought that representation fees were a form of membership, and so under this court's precedents, that would fit that definition.
Perhaps a form of membership, but it's just the idea that the two things are one and the same. It's just not usually the way we use the word membership, right?
That might be true, Your Honor, but again, so our primary argument is that because 8A3 and 14B regulate the same subject matter, that is, these agreements that require membership as a post-hiring condition of employment, that whatever forms of membership the unions can negotiate for under 8A3 are the same forms of membership that the states, by virtue of 14B, may prescribe. So even though there might be different species of membership under 8A3, it remains the case that to the extent, they're negotiated by virtue of 8A3, they're prescribable by a state right to work law.
So you're taking, I understand why you would fall back on Beck. It's helpful to you, and given the architecture of the argument that you're making, but how does Beck itself square with the text of the statute?
Your Honor, just to be clear, our primary argument doesn't actually rely on Beck. Our primary argument is simply that whatever types of representation can be negotiated for under 8A3 can also be prescribed under 14B, and that's the D.C. Circuit reached that same conclusion in Journeymen and Apprentices 6 years before.
I'm not sure why anyone would listen to that court. The D.C. Circuit.
I'm in agreement with that.
Yeah, mediocre members of that court. At least one.
But the point is, we make the alternative argument, of course, that under Beck, the union's position would render 14B surplusage, but that's not our primary argument.
Your primary argument is that membership means the same thing both times it's used.
Yes, Your Honor, and in fact, in previous cases, this court has articulated precisely that same relationship.
I thought we left it open.
Right.
Well, it's true that as a matter of holding, this court left that question open in retail clerks, but the important thing to remember in that case is that that question wasn't actually presented because the parties one party, in defense of the Florida right to work law, their argument was that 14B allows the states to ban agency shops, but not that it's coextensive with 8A3. And so, it would have been unusual, to say the least, for the court to rule on a question that wasn't presented in that case.
Right, but the court went out of its way to suggest that it may in fact be the case that these two words don't have the same meaning in these two provisions.
That's true, Your Honor, but in the same case, this court said, quote, the agreements requiring membership in the labor union, which are expressly permitted by Section 8A3, are the same membership agreements expressly placed within reach of the state law by Section 14B.
Won't that, to your opponent's point, when you look at what they were trying to do in the legislative history, won't this essentially with free riders and unions, I know you point to some facts, but it seems to me that just human nature, free riders, everyone should take advantage of it, right? You can get all the benefits. What other benefits are there to the union that anyone would pay for?
Your Honor, it's hard for us to say what the benefits are because we're not unionized, but certainly in the status quo, there are people who have the option just to pay representation fees and nevertheless opt for membership. And so clearly, there are some circumstances under which people are not willing to or are willing to pay that premium. And we have to remember, of course,
But right now in Wisconsin, you can get all the benefits of being in a union minus whatever you can't even figure out here and get everything the union members can get without paying. That sounds like a pretty good deal. Why won't that just eliminate unions in essence?
Well, two responses to that. First of all, there are incidental benefits to membership other than representation.
What is that?
Being able to stand for election as a union officer, being able to vote in those elections, to name two.
But that's also, you can get people that can do the things you need done that everyone benefits from.
True.
Right? Because the bargaining benefits everyone and that's the main benefit, it seems to me.
True, but in response, my second point is that
Wait, can we just stick to the first point for just 1 second, which I just want to make sure I didn't miss it, which is if the advantage is that you can become an officer, divorced from what you're becoming an officer to do, why can't you just get that same advantage by just creating a club and say, I want to be the officer of the Me Club?
Well,
because it has nothing to do with what the club does. So I don't understand the advantage to running for office.
I think generally in the course of things, the officers of unions are paid. It's a paid position. And so that would be the only sort of benefit that you're only entitled to stand
I see,
for
so it's the
election
compensation that comes with the
Yes.
becoming an
Yes,
officer.
Your Honor.
Okay.
But to the second point, in the 27 other states that have right to work laws, empirically, as the Seventh Circuit observed in Sweeney, those states still have unions that are completely functional. In fact, Iowa, which has had a right to work law as strict as Act 1 since 1947, has a robust union presence. And so it's just not clear empirically that this
Why?
is...
What is it? Why? I take your point. I mean, there's force to the proposition that unions continue to exist, and there must be some benefit.
Well, I think it's because, sorry, Your Honor, but I think it's because people recognize that unions are valuable, and so notwithstanding the fact that they can opt into the representation fee structure, notwithstanding the fact that they can pay nothing and still be represented, they understand that if everybody were to take that action, that unions would collapse and the benefits of being represented wouldn't be there, and so...
So it's sort of like a Good Samaritan thing.
Yes, Your Honor.
But it seemed to me, in looking at the legislative history, that, I mean, Congress might well have contemplated some Good Samaritans would stand up and carry the burden for everybody else, but that's still not what Congress wanted to happen. That was not an ideal resolution from Congress's perspective. There seems to be a real concern, even if unions don't collapse, about an inequitable sharing of the burden.
It's true, Your Honor, that there are references to the free rider problem in the legislative history, but there are also a lot of references to to Congress's desire to give states the ability to exempt themselves from 8A3's default rule. And in fact, those references actually passed bicameralism in presentment and ended up in 14B.
Right, but if you read the legislative history as a whole, it looks like the Congress is really sort of pursuing two competing interests and trying to come up with some kind of a balanced solution. And so I don't understand why the better reading of the statute isn't a more balanced one where, yes, states are free to prohibit clothes shop, union shop, agency shops, but what they can't do is go all the way to the other side and prohibit not only sort of a general monthly fee that's germane to representational activities, but even like a fee for services kind of arrangement.
Your Honor, it's important to recognize that the only cases in which this court has talked about the free rider problem are cases that involve only 8A3, not 14B. So retail clerks doesn't mention the free rider problem at all, but then Beck and GM do. And we think this suggests the following interpretation, that 8A3 was meant to resolve the free rider problem, the two competing interests of compulsory unionism and free riderism on its own terms for states that allowed it to operate as the default rule, but that the states, by virtue of Section 14B, are able to exempt themselves, as this court said in Atomic Workers, from that default rule. And we think that that pays respect kind of to both of those competing intents.
The upshot of that is that protection against the free rider problem for unions is completely at the election of a state. So in a state that elects to have a law like Wisconsin's, we have to assume that Congress thought the free rider interest just completely gives way.
Yes, Your Honor, that is our understanding of what Congress passed.
And if that's right, then what do we do with all this legislative history where at the time they passed it, they were concerned about the free rider problem?
Your Honor, as you acknowledged in the previous oral argument, legislative history is kind of a many-headed beast. I mean, you can look out into the audience and see your friend and kind of elevate that to the point of swallowing the rules. So I think what's important to recognize here is that notwithstanding what Congress said in the legislative history, they ultimately passed Section 14B, which, because it incorporates by reference membership agreements from 8A3, gives the unions the ability to...
But what do you mean it incorporates by reference? It doesn't say. I mean, doesn't it do the opposite of incorporate by reference? There's no reference back to as defined for purposes of Section 8A3.
That's true, Your Honor. It's not a formal...
It doesn't incorporate it by reference.
It's not a formal incorporation.
Because that would make it a lot easier. Well, how is it an informal incorporation?
Well, the point is that the authority to negotiate membership agreements doesn't appear anywhere else in the statute. It only appears in 8A3. And so it would be kind of contrary to normal methods of interpretation to think that 14b, by invoking the term membership agreement, refers to something other than the only other place where that same term appears.
Yeah, the reason I'm pushing on this is because it really does strike me that Congress, if this is what Congress meant, it would have been so easy to say so, either by incorporating by reference, which it didn't do, or just by saying agreements requiring membership in a labor organization or payment of fees to a labor organization. But it didn't say that. It just seems like if this is what Congress meant, why didn't it incorporate by reference or say it clearly?
Certainly, Congress could have drafted the law better. I think that's generally true. But in this problem, Congress understood that the only way, or in this case, Congress understood that the only way that unions could compel those fees is by virtue of having a membership agreement. And 14b was the response to their concerns about whether or not that would totally preempt state power.
So is there any way the union can get compensation for non-members for services they provide?
Well, the first way is that because they have the exclusive representation power, they're not undercut by other unions, and that allows them to inflate their fees that they charge their actual members. And in that case...
So the non-members are getting an even better benefit under that scenario?
I suppose, Your Honor. But the more important point is that, as you noted in the previous oral argument, the unions have the option to be a members-only union. And this is not, just to be clear, this is not a feature of Wisconsin law. This is something that can be negotiated across the country unless it was specifically contrary to state law. And because they had that option, and yet they chose to stand for election to be an exclusive representative, and this is previewing the merits of my co-counsel's argument a little bit, but the exchange of that benefit for the correlative burden makes this not a taking. And so because this isn't a taking, for other reasons too, we don't really have to reach the compensation question. But even there, my co-counsel has some great arguments on that point. So I started this by saying that we could resolve this question through the text alone. But even if you look at the legislative history, as we think the unions would have you do, that really cuts in our favor ultimately. So the House Committee report on the language that became Section 14b said, quote, agreements such as those that Section 8A3 permits are valid only if they are valid under the laws of any state in which they are to be performed, unquote. The upshot of that is two things. First of all, this shows that passing state law is a necessary condition of a union security agreement being valid. So in that case, Act 1, the agreement would have to pass that. But second, it also shows that Congress contemplated union, or state laws rather, to be stricter than Section 8A3. And so they understood, as this court understood in its previous 14b cases, that 14b would give the states the ability to regulate these agreements more strictly than 8A3 does.
So that dovetails with your superfluity argument, which is the idea that 14b must allow states to prohibit something that's not otherwise prohibited under 8A, right?
Yes,
That's the nub of your argument. So why is that? Because, for example, state law and federal law often criminalize the same thing. But nobody thinks that state law is superfluous because it criminalizes the same thing that federal law does. So what's wrong with having a regime under which state law prohibits something, federal law also prohibits the same thing, but you've got different enforcement machineries. It may be that federal law, for a federal claim for whatever reason, or the federal agency decides not to pursue a particular case, but a state agency that's responsible for a similar scope of prohibitions decides to pursue a case. Why doesn't that explain the fact that you might have superfluity and substantive scope, but it's not superfluous in the sense that we would care about?
Your Honor, the argument here is not that that the union's interpretation renders Act 1 surplusage, it's that it renders 14b surplusage, because...
that's what I mean, yeah. So in other words, I thought the idea behind that is that 8A already tells us that there are certain things that, as a matter of federal law, aren't protected and are prohibited. And what we should do, you would say, and as a conceptual matter, this makes sense, is construe 14b in a way that doesn't make 14b just completely repetitive of 8A. In other words, that 14b doesn't mean states get to prohibit only those things that federal law already prohibits under 8A. And I guess what I'm saying is, even if you have 14b only giving states license to prohibit that which is already prohibited by federal law under 8A, that still is not necessarily superfluous because you've got different enforcement machineries and you've got different maybe enforcement priorities or something like that that would
Well, certainly one reason not to take that interpretation is that I don't think Congress would want to muddy the preemption analysis. And what having 14B and 8A3 does is it muddies the preemption analysis under Garmin, because if 8A3 existed by itself, Garmin would show us that Act 1 would clearly be preempted, but by having 14B there too, that suggests that 8A3 is not preempted and that Act 1 is valid. Thank you. I see that my time has expired. May I briefly conclude?
Sure.
For the following reasons, or for the foregoing reasons rather, Act 1 is not preempted by the NLRA, and Sections 8A3 and 14B should be construed as coextensive. Thank you.
Thank you. Mr. Sowers.
Mr. Chief Justice, and may it please the court, my name is Will Sowers, counsel for the state respondents, along with Mr. Zack Ferguson. Under any theory put forth by the unions, Act 1 does not amount to an unconstitutional taking. We have three main points. First, the union's takings claim is not yet ripe. Second, even if it is ripe, it fails on the merits. Third, if Act 1 establishes an unconstitutional taking, much of the regulatory state as we know it is called into question. Government could hardly go on if compelled to regulate by purchase. To begin, the unions have a ripeness problem. In Williamson County, this court held that in order to bring a taking claim in federal court, plaintiffs must first exhaust remedies in state court.
What remedies existed? I mean, what remedy did the Act 1, or where is there a remedy provision?
Here, Wisconsin actually provides a private right of action under their constitutional taking clause. And we know that it is relevant because another union is pursuing a claim through Wisconsin courts.
Let me ask you something. I understand Williamson County, but the statute, the constitutional provision says taking without just compensation. So once you effectuate the taking, why isn't the burden on the state to pay immediately? Otherwise, you could effectively run all these unions out of town by just delaying the mechanism by which they can seek just compensation.
Well, Your Honor, part of it is because the states are the ones ostensibly being required to provide compensation. So the idea is that you go to the states first. And here, the state has provided a way to get compensation or an injunction if that's what the unions wish here, and that's through this private right of action. And in fact, previously, this court has held that state court remedies are an appropriate way to exhaust remedies. So it is an acceptable way to exhaust remedies.
But in a case like this where it is going to be a recurring cost, I mean, is this really the state's concept of how this will work, that every single time a union, say, does an arbitration for a non-member, each time it will go to state court and try to get compensated?
Your Honor, to the extent that this is a recurring cost about what the union referred to today as discrete services, that makes it even more an as-applied challenge. Because in that sense, we have to determine what the cost of the individual service was in each individual
Can you just answer my
instance.
question, though? Is the idea that the union should go through the state court system each time it conducts a grievance or each time it negotiates a new contract? So, you know, hundreds of times a year it'll go?
Well, Your Honor, we would first argue that it will fail on the merits no matter what, because it's not a taking.
Okay.
But even so, were there a taking here and they needed to exhaust those remedies, yes, they would need to exhaust them, either saying overall these are the services, this is the, as the unions mentioned, the money being taken out of the treasury, or these are the individual acts that we're required to do, or they could take a broader approach as well. But the approach that the unions have taken today is to say discrete services.
Isn't there something a little bit odd? You represent the state. You're the entity that's alleged to have perpetrated unconstitutional taking. Isn't there something a little bit odd about you being the state and saying there hasn't been a taking at all in the first place, but then also simultaneously saying, and by the way, you should pursue this remedy to get just compensation? Because it seems awfully strange for the state to be saying, on one hand, I didn't take anything, and on the other hand, by the way, you should go seek just compensation for the thing I didn't take.
Perhaps, Your Honor, although first, that is the framework that was set up in Williamson County, and second, it's the state judiciary that's making that decision, and the state judiciary is independent and make decisions based on the law. And then finally, just because they exhaust state remedies, they aren't preempted from pursuing a claim should they not like the outcome in federal court. They exhaust their remedies, and then they are free to bring those claims here. But even to the extent that you're not persuaded that they do have a ripeness problem, even if it is a facial claim, it still fails on the merits. And so in a case such as this, we look to the Lucas and Hodel test, which says that you must show that your property, and we'll talk momentarily about whether or not union services are property, but for now, just the overall merits, your property has been denied all economically viable use. And this court has set that bar extremely high to say what all economically viable use is.
But here, and I know you said you'll get to it in a minute, but it seems to me if you're taking the union's money, which is in effect what you're doing, you're denying them all use of that money. So if they do an arbitration for someone that is not a member, because the state's requiring them to do so, and it costs them $20,000, you're taking a significant chunk of money from them.
Your Honor, in Eastern Enterprises, this court did indicate, although it was in a concurrence and a plurality decision, that providing services is not the same as taking money. So in that case, this court recognized that the regulation there was a staggering financial burden, but it was simply an obligation to perform an act, not a taking. And so in that sense, acts and...
That seems ridiculous because, okay, so if we said as a matter of getting a Wisconsin bar license, you have to perform 50% of your services for indigent clients, you would say that's okay, right?
Yes, Your Honor, because right now, as a prerequisite for getting a bar license, lots of states require that you do pro bono work, or as a prerequisite for having a license, you have to do continuing education.
Well, what if I said 80% of your work? I mean, it seems to me that at some point it's got to cross over, and here what's happening is you're taking a significant chunk of money from the union and requiring them to provide significant services. And why isn't that a taking? You're effectively causing a transfer of wealth.
So there are a variety of reasons, but I think you're asking specifically why aren't services a compensable property interest here?
You can go that way, or you can do what your opponent does and says it's money that you're really taking, not services. You're taking money out of the union's coffers.
Your Honor, if this court holds that any time a service is compelled, it's actually money and that therefore there needs to be just compensation, that has a huge impact on the regulatory state. So for instance, every time a large company hires somebody, they have to fill out a Form I-9. Every time an indigent patient comes to a hospital.
Yeah, but they're getting a direct benefit from hiring someone.
And Your Honor, so that's where we get to the idea that here there is a benefit in exchange for the burden. So the burden here is the duty to provide services to everyone, whether they're a member or not. But the benefit is that they get to be the exclusive representative. And that is a big benefit.
But that's your compensation argument, right? That even if there was a taking, there was a compensation?
Yes, Your Honor.
All right, I'm still back on whether or not, how it can be that this isn't a taking. And I guess I would ask the same question that one of my colleagues asked your colleague. If not a taking exactly, isn't it a substantive due process violation to tell the union? I mean, doesn't it interfere with their economic liberty or other forms of liberty to tell the union, you have to go do this arbitration for a non-member and you cannot recover your costs? You just do it as a favor to the federal government.
Your Honor, I have not studied the due process issues here, partly because the unions did not bring them up here, which leads me to believe that they didn't think that there was a strong enough case there.
Yeah, but you are relying on sort of the Eastern Enterprises plurality, and so that makes me think Eastern Enterprises tips the other way because of Justice Kennedy's due process opinion. I'm just wondering if there's another way to conceive of this under Eastern Enterprises.
Perhaps, but the unions would need to bring that argument here before the court, which they chose not to.
Well, let me try to shape it this way then. Suppose that instead of the law being configured the way it is, what the law does is this. It says it doesn't prohibit the unions from getting money from non-members. But what it says is any money you get from non-members for these services, you need to turn over to the state. And the money that's turned over to the state is for whatever public use you say in your brief is being supplied by this law to begin with, because one of the arguments you make is that this serves a public purpose. So there's actually a transfer of money. The money goes in the union account, and then the state law says, but we're effectively doing the same thing as denying you the ability to get the money in the first place, but we're telling you is that you pay the money into an account, and then you pay that money over to the state. Would you say that there's not a taking in that situation too?
Your Honor, I think that's different because money is a compensable property interest, and in that hypothetical, the government is going directly in and taking the money out.
But it seems like their point is that's functionally what's happening here, is that you're basically requiring us to render the service for which we otherwise would have been paid, and you're preventing us from getting the payment, which is basically the same thing as saying, okay, you can be paid, but then whatever you get, we're going to zero it out and you give it to us.
But the government requires services or activity in order to enter a market in all sorts of circumstances. So for instance, as Justice Thapar mentioned in Int'l, in the Emergency Medical Treatment and Active Labor Act, doctors, hospitals have to provide services.
But there has to be some limit on that, right? Could a state decide that it thinks it's too expensive for employers to defend themselves in Title VII cases, so it's going to require anyone who does transcripts of trials to provide them for free to employers who are defending Title VII cases? We know you usually charge for this, but if you want the right to do this in our state, you're going to have to do it for free for big employers who are defending against Title VII suits. Would that be all right?
I think that's a difficult question, Your Honor, and I think here, since this court has not yet recognized services as a compensable property interest, this court would have to take the affirmative step there to recognize services.
Well, should it? I mean, I really am trying to, is there a difference between that case and this one that you can give me?
There is a difference, Your
What's the
Honor,
difference?
and the difference here is that the unions have the ability to become a members-only union. They can become a members-only union, and then even accepting their novel
Well, you don't have
takings-
to do transcripts. I mean, you could find a different profession.
Certainly, Your Honor. I'd say the difference is that the services are exactly the same, whereas you'd have to
But
leave your-
it seems odd to me that you could take, if what we're making is bottles, that you could take the bottles without giving compensation, and we're gonna say, no problem, or a problem under the takings clause, but you can make someone do something. Same time, same cost to the person doing it, and yet we're gonna say that's not a taking. Why would we distinguish services?
Your Honor, I think there may be a case in which you don't distinguish services, but this cannot be that case because there's another opportunity to provide those exact same services as a members-only union. However, this court has the difficulty of recognizing services as the enormous slippery slope that provides, because then all of these other examples, such as the Fair and Accurate Credit Transactions Act, where the government requires credit reporting agencies to provide a free credit report to every consumer every year, all of a sudden that's a taking, and the example of Int'l, that would be a taking, and it's an enormous slippery slope problem. The other issue that we get to on the merits here under Lucas Hodel is that the unions have to show that their services, if they are a compensable property interest, have been denied the entire economically viable use. And that's an extremely high bar. So in Eng'rs, this court looked at a law that Congress had created which said that eagle feathers could no longer be sold or traded. And the Indian artifact traders said that is a complete economic denial of our property. And this court said, no, you can use those Indian feathers and open a museum to invite people to look at them that way. So it's an incredibly high bar. It's not just the most valuable use, the use you want to put them towards. It's any economically viable use. And the unions can't show that here because, as a matter of fact, people do choose to be members in a union even when they don't have to, whether that's in right-to-work states where no right-to-work state has no unions in it at this point, or whether it's in situations where they could be non-members and only pay the minimally required dues, but still choose to be members.
And Howard, when you make that argument that there's still an economically beneficial use, what property are you talking about as to which there's still an economically beneficial use?
I'm talking about I would argue that the denominator is the entirety of the services, because if you can just minimize the denominator, especially with services which are so fungible to exactly the portion of services which you feel are being impacted, they could be anything in any given case. And even more, if you can minimize it in that way, then it pushes us back to the fact that this is an as-applied claim. However, even looking at those impacted, the unions still run into a problem, even if we minimize the denominator to there, because people still choose to pay for those services even when not compelled to, as we see in other right-to-work states.
Can I ask a question about getting back to ripeness for a second? If you have a statute that requires a transfer of money, and then the claim is brought that says, you can make up your hypo, but it's at the end of the day, what the statute does is it requires a party to turn over money, and it says, this is for the following purpose. Does the idea that you still need to go seek just compensation apply when the entire statutory regime requires just the payment of money?
I believe that it does, Your Honor. We haven't seen a case in which that was held differently, where there was an exception for the fact that you were required to pay money.
Because it just seems crazy to say then that what would happen with that statute is by the way, here's my law, you have to pay $50. And then what you get to do is go to court and try to get the $50 back. Because obviously, I'm not giving you the $50 back because the purpose of the law is to get the $50 from you.
And perhaps there the appropriate remedy is to be able to have an injunction in that case that you don't have to pay before it's decided in court. But here, again, we're not talking about money. And if every time you compel somebody to do an act that costs them money, that could be a taking, that we're looking at the money as the thing that's being taken, that's a hugely slippery slope.
Isn't it a slippery slope the other way too? If the government can compel you to do whatever it wants, provide whatever services it thinks would be beneficial for free? I mean, if there's no stopping point for that, that seems problematic also.
But it's not for free, Your Honor, because of what this court expressed in Ruckelshaus v. Monsanto, where the requirement to there was give over information that you wanted to keep away from competitors that would be given to those competitors. The voluntary submission of data in exchange for an economic advantage can hardly be considered a taking. Thank you.
Thank you, counsel. We have time for rebuttal, I believe. Is there some time?
May it please the court? As Justice Harris indicated, what Congress was concerned with in Section 8A3 was this inequitable balance of power. And this court has consistently recognized that Section 8A3 represents the legislative solution to the free rider problem. In fact, in Beck, this court expressly recognized that Congress intended to eliminate free riders in enacting Section 8A3 by empowering unions with the ability to address the free rider problem, to seek this compensation from non-members to help neutralize the costs of fair representation.
Do you agree that Iowa's statute is as restrictive as Wisconsin's?
Yes, Your Honor, I believe the language is substantially similar.
And that was passed right in 1947, right, when this was passed, right?
Yes, Your Honor.
I mean, why shouldn't we give that some weight as to what it means? I mean, Iowa thought right when this passed, boom, it's right to work law.
Well, Your Honor, simply because Iowa did pass a law, regardless of the language in 14b, is not evidence alone that it comported with the language in 14b. And even though unions do survive in that state, that is in spite of the right to work laws.
But it happened right away, and Congress didn't do anything about it, in spite of knowing they had just passed this. Why isn't that strong evidence of what membership means in this, that it gives the state the right to do it?
Well, Your Honor, from congressional silence, we could either infer support of the state law or infer that they wanted the unions in that state to challenge the law. And in fact, the recent proliferation of state right-to-work laws has only led to a greater proliferation of legal challenges to those existing state laws, demonstrating that, in fact...
Were there challenges before the D.C. Circuit heard the case, I think, whenever that was, 1960s or whatever, 70s?
Your Honor, I believe there were challenges to state right-to-work laws that were decided at the district court level, but that the D.C. Circuit was the appellate decision.
That was the only...
Yes, Your Honor. There's only been 2 appellate court decisions. Both were closely divided at 2-1, the Sweeney case and the Pipe Fitters case. And what that demonstrates is that this court, in recognizing the Section 83 as the legislative solution, is that there is this confusion and question regarding the validity of these right-to-work laws, that they don't necessarily comport with 14b simply because they're on the books. And this court left open in retail clerks whether the 2 sections should be found to be perfectly coincident. And the language in both sections, along with their underlying legislative history, demonstrates there should be a gap left open, that unions should be able to seek these representation fees in order to cover the costs of fair representation, or otherwise there will be the resulting free rider problem that Congress sought to prevent. And Wisconsin Act 1 goes far beyond even just regulating representation fees by driving the charges down to 0, prohibiting any compensation whatsoever. And that transfer of funds from the, may I briefly conclude, from the union to the non-members, both goes far beyond compulsory unionism under Section 14b, but also renders an unconstitutional taking under the Fifth Amendment. Thank you.
Thank you, Ms. Compton. Thank you, all counsel. The case is submitted.
All rise.
Congratulations to our finalists who have worked very hard, put forth a tremendous effort this evening. The judges will now deliberate and will return shortly to announce the winners of the 2018 Dean's Cup. Thank you.
All right, please be seated. So congratulations to both teams. I know this has been a long journey and a lot of hard work, and it absolutely showed through in your performance today. It was really fun to be a part of this. I think I'll speak for both of my colleagues in saying so. You guys ought to be tremendously proud. I don't know if your families are here. If families aren't here, they missed out. If families are here, they should share in your pride, because this was obviously the product of a great deal of work and a great deal of thinking. And I think all of us had the same reaction about one aspect of this, which is this is a hard problem. This is and it's not just hard in the sense that it's hard to decide who's right. It's actually hard to understand. This is conceptually a very difficult issue. And even just on the statute, just trying to figure out how these provisions interrelate, I mean, you have to draw Venn diagrams. I mean, this is very tricky, and I think you're all to be commended for keeping it well organized in your own mind and in your presentation. So kudos to you, congrats, and congratulations to the people who put together the moot court. Very nice job with that, and I'm sure you feel very satisfied with the way these folks performed today, and to the school for putting on such a great show. And in terms of, we're faced with what we usually do as judges, which is we have to render a decision and decide. And we didn't write the opinion yet, and we're not going to announce who won in terms of the bottom line. But we do have to pick some winners in terms of the various aspects of the competition. And I'll preface this by saying what everybody always says, but which is actually true, which is it was very close. It actually was incredibly close. You all did a great job in various respects that maybe we'll get into. But what we did was we decided which side had the brief that moved us the most, which side had the argument that moved us the most, and then which side ultimately prevails. So in terms of the best brief, we gave the award to the respondent's brief, and both of you all did tremendously insightful and clear briefs that made the case, even as complicated as it is, digestible. So congratulations, but respondents get the award for the best brief. For best arguments for advocacy, we'll give the award to the petitioners. And again, all four of you did a tremendous job today. And for best overall team, and I think this is in part heavily leavened by the fact that as appellate judges who deal with these cases in the real world, cases are won and lost much more often on the briefs than at argument. And so in part as a consequence of that, we give the best overall team to respondents. But congratulations to all of you. You guys should be really, really ecstatic about the way things went today. So. And then we'll just give a couple of reactions, maybe some brief reactions from the terribly insightful panel that sits up here and meeting the other two. So we'll start with Pam, with Judge Harris.
Well, I just want to really very briefly echo what Judge Srinivasan has said. I thought all four of you were great, and I thought this was a really hard problem. It really allowed you to show your stuff. This was a hard case. We struggled on just trying to figure out the statutory scheme and then this takings argument. I mean, they were difficult in different ways. The statutory argument was so intricate and so complex, and there were a lot of moving parts, and then Beck comes out of nowhere and changes everything. So that was complicated. And then on your takings argument, there's nothing. I mean, it's complicated. It's hard in the other way. You're just kind of, it's all first principles. So I thought distinct but equally difficult challenges on both sides, and I thought you did a really, really good job. The only thing I would add about the arguments is, and I think this goes for all of you, it is really unusual in my experience to go to a moot court and have students who are so prepared to kind of engage kind of where judges are. Like, how does this make sense? How is this going to work? Where's your limiting principle? I'm much more accustomed to seeing students kind of try to protect themselves in case law. Well, but the Sixth Circuit said this, and you guys were great. I thought you really all stepped up to the hard questions and were prepared to engage in things that really move judges. How do I make sense of this? How's this going to work? How is this a manageable rule you're asking me for? And I thought you were just sort of right where we were in terms of our concerns and our genuine questions. And I really, really commend you for that. I think it's very unusual, and I was really impressed.
Amul, Judge Thapar.
Yeah, so I would say a few things. One thing I figured out in watching the four of you is that as contingency for doing moot courts, we should make sure that you all have to do pro bono work in our courts. And I think I should have cut that bargain, especially this time. I can tell you, I've done 10 years of judging and 10 years probably, unfortunately, of moot courts and judging. And I've never seen anyone better. And so at some of the moot courts, I've seen people as good as you, but never better. And I thought this problem, as Judge Harris just said, was incredibly complex for a moot court. And you all did a great job with it, like a really great job of distilling it and talking to us about whether it be first principles, line drawing, whatever we were getting at. But I was really impressed with everything you all did, your knowledge, your ability to discuss things with us, and your ability to engage with the difficult issues. So I really hope that you all will consider doing this. I think it would be as a career and also at least in the Sixth Circuit. So I hope you will think about that.
The Fourth Circuit is closer, if I may.
That shouldn't matter. I promise you'll have fun in the Sixth Circuit.
So just a couple of quick thoughts. So some things really stood out to me. One of them was the complete, utter lack of nervousness, which I think is really, my guess is you were nervous, but because I think it's hard not to be, but you didn't betray it in any way, shape, or form. So that really takes a lot of tremendous fortitude and discipline, so congratulations to you. Either you guys are preternaturally confident or we're amazingly unintimidating, but something happened there where it was just a really nice, unnervous presentation, so that speaks really well of your futures as lawyers, I'll say. Incredibly even-keeled, so devoid of unnecessary overstatement, which is hard to do, especially when you're a green lawyer. I think a lot of times the temptation is to prove how right you are by saying it, rather than by letting the substance of the arguments show how right you are, and I thought all of you were even-keeled, measured. You actually appeared interested in answering the questions and were intellectually engaging with them. And whether you mean it or not, that's a good thing to indicate to a judicial panel, because I think we respond very, very favorably to that kind of dynamic. And the last thing I'll say is, and this is about cases which Pam mentioned, and which I totally agree with. I think a lot of times it's tempting to come up to the podium and argue why, based on the following sets of cases, you said this, you said that, and therefore you have to rule for me. And I've always thought that cases are best used defensively rather than offensively. And if you have your argument start out offensively by why you should want to rule for me, and then you use cases defensively to answer questions and to say, well, that might have been a better argument before you decided back and said the following, that works really well, I think, because we can deal with our own cases, especially if we, in this fictitious universe for Supreme Court justices, you have that authority. And the way you all use cases was, I thought, very sophisticated in the way that the very best appellate lawyers do. So congratulations to all of you. Feel great about it, and now you can relax. So.